Good morning. My name is Malcolm Neekirk, and I'm going to say welcome to Fretton's 8th coffee break briefing of this year. Today is going to be a refresher on GDPR. So there are a number of issues I want to talk about in talking about GDPR this morning. I'm going to start with a quick canter through the basics, and then I'm going to talk about the first of three, what I suppose you might call the management issues, which is training. And then I'm going to be talking about the three areas where GDPR will affect you directly in your professional life. And the first of those is how GDPR applies to insolvency practices as it does to all professional service firms. Second one I'm going to talk about is what I'm calling step-in GDPR issues. And these are where you are appointed, usually over a company, over a business of some sort, where that business has got pre-existing GDPR obligations that you need to be aware of and that you need to deal with one way or another. The third one is the one that is unique to insolvency practitioners, and that is how GDPR affects you as an office holder, in which capacity you yourself will be a data controller and subject to direct obligations under GDPR. So those are the three frontline areas I'm going to be talking about. Then I'm going to be moving to talk about a couple of occasional issues, things that you need to be aware of, but which are not part of everyday practice. And they are error reporting, what to do when things go wrong, and subject access requests, what they are and how you need to deal with them when they arise. And then the final 2 points I'm going to finish with are again a couple of management issues, and one is a quick canter through the policies that I think you probably ought to have in your firm, and finally the points that your compliance partner in particular will need to be thinking about. I hope to cover all of that, as I said, in half an hour or so. So let's move on and start looking at the basics. And three things I'm going to be looking at is, firstly, what is GDPR? Second thing is the evolving law of privacy, of which GDPR is a very important part. And thirdly, what was new about GDPR that meant that everybody was getting so excited about it in 2018 and 2019? Well, the law itself, there are two main parts of it. There's the General Data Protection Regulation, which is a European regulation known as GDPR to its friends. And then here in the UK, alongside that, we have got the Data Protection Act 2018, which replaces earlier data protection acts and essentially provides a bit more detail as to the implementation of the more general policies required under GDPR. Both of those now have been amended by the snappily titled Data Protection, Privacy and Electronic Communications, open brackets, amendments, etc., close brackets, open brackets, EU exit, close brackets, regulations 2019, which I will refer to as the Brexit regs. And as a result of the Brexit regs, which made a huge number of very small and usually for practical purposes, inconsequential amendments to GDPR and the Data Protection Act, we now have UK GDPR, which is GDPR with a Union Jack thrown over it to distinguish it from the previously blue version of GDPR with gold stars on it. And we also have the Data Protection Act 2018 as amended, and that's where the law now is. It hasn't got any simpler as a result of us having GB or UK GDPR rather than the original GDPR. If anything, it's got more complicated because you need to track through and understand all of the details. And on a historical note as well, the GDPR itself was developed from UK legislation, originally the 1984 Data Protection Act, which was one of Margaret Thatcher's key pieces of legislation, and it gave people a statutory right over records that would be held about them. And it's been developed, accepted across Europe, and developed into what is essentially an international standard, so that even the United States, to the extent that they want to do business with Europe, they have to make sure that their own data protection laws are compatible with the general principles of GDPR. So it's not GDPR is not going to go away anytime soon. It is essential for international trade. And in terms of it as a developing law of privacy, there's the historical background, which I've really already given to you. Traditionally, UK law has not given people a right of privacy as such, and in that sense, GDPR and its predecessors were something new. And it's probably also worth mentioning, because this helps to understand GDPR, its principles and its implementation, that it is really a piece of human rights legislation. The idea behind it is that all of us have a right of privacy. We all have the right to have a degree of control about what information is kept on file about us and who uses it and how it's used. So that's really what is at the essence of it all. And I will mention here the golden rule, which is that if you ask yourself a question, how would you as an individual like other organizations to treat you and the information about you that they have got? If you use that as the basis for your own policies, procedures, and implementation, I don't think you're going to go very badly wrong. In terms of the detail of GDPR and what was new in it over and above the data protection legislation that we had before then, there was a lot of extra paperwork. So in particular, you needed to have rather better compliance records than had been necessary under previous information. And there were also some better improvements to the rights that individuals had under GDPR. And these were really just marginal improvements rather than anything that was dramatically new. But essentially, you're now entitled to be given better information about your rights under GDPR, better information about the files that are kept about you. And businesses now have to actually think about why it is that they think they have the right to use information about somebody and just record their reasons for that. So that's the basics. I'm now going to move on to talk about training. And it is a requirement of GDPR that you should be training your people in compliance. And really the training needs to be firstly for your compliance partner to make sure that they are fully up to the latest thinking on GDPR and how it works. But really everybody in the organization who handles personal data needs to have regular training on GDPR for legal compliance. And personal data, one of the key concepts here is really any information that you have got about an identifiable living person. That's what personal data is. And GDPR came into force in May 2018, just over 4 years ago. You almost certainly will have had training on it at that time. Now it's coming up for 5 years later, so it's probably a good time to schedule a refresher if you haven't had one, and then probably follow up refreshers every couple of years after that. And of course, GDPR should be part of your induction program for people who join you. And in terms of what you should have in your training program, well, I think there are three areas that it should cover. First of all, the basic principles behind the legislation. And the idea here that when it comes to collecting information about people, you should take only what you need and no more. You should keep only what you are allowed to use, and you should keep records about why you are allowed to use it, how that right to use it is legitimate under GDPR. Something that I would emphasize in a training program, particularly for insolvency practitioners, is that consent is not the only way that you can be authorized to use personal information about somebody. There are other routes for doing so. And in the context of insolvency work, some of those are a lot more useful than consent. And I would also mention, as part of the training program, the golden rule, the idea that if you treat other people's information in the same way that you would like a responsible organization to treat information it's got about you, you shouldn't go too badly wrong. The training program will have to be specific to your own firm and will have to cover your own policies, procedures, and the documents that you use in your GDPR compliance to make sure that people are familiar with that. And I think it would also be very useful if the training program ensures that people know what is special category sensitive data, how to recognize it, and why it's important to recognize that. So I'll move on quickly to the different categories of data that you might have in your files. This is probably in the wrong order, with the highest priority at the bottom of this list rather than at the top. But I'll start at the top with the least protected category, which is anything that's not personal data, anything that's not about an identifiable living human is not protected by GDPR, but it may still be under professional or contractual duties of confidentiality. So there may still be good reasons for keeping that sort of information confidential. The first category that is covered by GDPR is personal data. Second category I've got on the list is financial and identification data, and that's not actually a specific statutory category, and there's no express statutory reason for giving that sort of information a higher degree of protection, except that releasing it can cause immediate and very measurable harm to people. So for that reason alone, you might want to keep it in a higher category than the rest of the personal data that you're keeping. The next specific category is special category personal data, which should be regarded as more confidential, and there are fewer circumstances in which you can use it. I'll say a bit more about that in a moment. And the highest category of sensitive data is what I'm calling here criminal records, but it's actually a bit wider than that, and I'll say a bit more about that as well. So special category sensitive data is essentially information about somebody's health, their sexual life, their religion, their political opinions, their racial or ethnic origins, and their trade union membership. And also new in GDPR, because this list was basically carried across from previous legislation, the new one in GDPR was biometric data. And all of those are special category sensitive data, and there are tighter rules about when you are allowed to take that information, about when you're allowed to keep it, and when you're allowed to use it. And there are even tighter rules for criminal records. And here, this isn't just records of convictions, it's information about crimes that have been alleged, prosecuted, convicted, or sentenced. And that word alleged is an important one here, because essentially this means that your file about CDDA investigations and indeed other liquidation files with investigations on may contain information about alleged crimes. And these could also be in a personal insolvency context, bankruptcy offences, or allegations of fraud. And of course, it's not that unusual in an insolvency to have angry creditors making allegations of fraud. You do need to be particularly careful about how you circulate that information and how you use it. Moving on to look at GDPR in professional services firms such as insolvency practices and many other types of professional services firms. There are three areas where GDPR will affect you. First one is in marketing, and each of these three areas, I'm just going to show you the slide. It will be in the handout, but I'm not going to say anything more about it. Second one is in your HR records, where of course this will be information about people, and it is likely to contain sensitive information, could even contain information of the most sensitive sort, allegations about activity that is criminal. And the third area is, of course, in your client files as well, where you are actually working on particular cases, pre-appointment and post-appointment. And you need to distinguish between the files that the firm is keeping and the files that you are keeping in your personal capacity as an appointment holding office holder. And I'll talk about that a bit later, but before that I will talk about the step-in GDPR issues, and this is where you are involved with a business. You might be acting as administrator. It's unlikely to be pre-appointment. It will be after there has been some sort of formal appointment. Could be as liquidator, but it's probably most likely to be in administrations where this is going to be an issue. And the key thing here is that there are separate responsibilities for the company and for you as the office holder. And in particular, you do not become the data controller, the person with legal responsibility for GDPR compliance in the company in administration, even after you are appointed. Before you are appointed, it will be the company itself that will have been the data controller for its own files and information, and that is not changed by your appointment. They continue to be the data controller. You will be agent for the company as administrator or liquidator, but that doesn't mean that you take over from the company. You may have responsibilities as data processor on behalf of the data controller, but those are a lower class of responsibility, and that will depend upon the circumstances of the case. The implications for you, and I will again just skip through these slides, but they will be in the handouts available after this. The first one for you is to make sure that you have got a good pre-appointment risk assessment. Doesn't need to be very detailed, but it just needs you to carry out it says there, a quick and dirty review. And you need a further review on day one as well, following appointment, just to make sure that the pre-appointment issues have not changed. There will be further implications for you and a further review needed if it is intended to be a trading administration. If you're going to keep the business open, then you will need a rather more detailed review. Again, I'm just going to skip over that slide for now. And another situation in particularly corporate appointments when GDPR is going to be an issue is that there may well be GDPR issues, data security issues around the sale of the business in terms of passing the HR records to the purchaser or selling the customer database or a marketing database. So those are what I'm calling the step-in GDPR issues, where you're standing on the sidelines. You're not directly responsible for compliance as data controller, but nevertheless, it is going to be important for you to make sure that the company under your control does continue to behave as it should do. The third of the active issues I'm going to be looking at is where GDPR does affect you directly as the office holder. And in many circumstances, probably most appointments, you will be a data controller. And this is a second appointment as data controller on top of the pre-existing appointment of your firm as a data controller for its own business records. So as office holder, you're going to have, in personal insolvency cases, information about the bankrupt, their family and their associates. All of that will be personal data that you will be using in your capacity as office holder and for which you will be data controller. Similarly, in corporate appointments, you will have information about the directors, their family and their associates, and probably others as well. This means that you will need to identify the legal basis for you to collect, hold and use that personal data. And there are several. The most relevant ones from GDPR that apply to insolvency practitioners are the ones listed on this page. First of all, consent. And I really don't think as an appointment taking insolvency practitioner, you should be relying on consent very often as your basis for using personal data about people. And that does make you, as insolvency practitioners, really quite different from most other business organizations where consent can be a very important part of it. And it does mean there's an awful lot of the more generic advice about GDPR is actually not terribly well targeted to insolvency practitioners. Second basis that you may have for using personal data is for the performance of a contract. That's particularly useful for IVAs, I think, where the contract is made directly with the debtor, but less useful for corporate appointments where the directors are independent from the company itself. Third one that you've got is legitimate interest, and I think that is a very important one, but that does require you then to carry out and record a balance of interests. On the one hand, you've got your obligations as an insolvency practitioner, the purposes for which you've been appointed, the work that you've got to do, your legal obligations. On the other hand, you've got the potential harm that could be done to the people that you are keeping information about, and you have to ensure that you've got the right balance of interests about that. The fourth one is your ability to use personal data to perform legal obligations. That's quite tightly drawn in its terms, so it doesn't catch everything that you're doing, but it can be very, very useful, and I won't be talking about the detail of that this morning. Similarly, there is some work that you are doing which can be regarded as being in the public interest or in the exercise of official authority, and again, that can be quite useful as well in terms of justifying some of your use of personal data. The legal obligation on you as an insolvency practitioner, as a data controller, is that in each case you have to identify which of those bases you are using for the personal data that you are collecting, and you should be keeping that on file. You should be keeping a written record of that. You will sometimes, as office holder, also be using sensitive data, and just a reminder there that that includes information about people's health, their personal relationships, family relationships, and allegations of criminal activity. All of that can come up and be very relevant to what you're doing, as well as some of the other areas of sensitive data. And you have got far fewer legal justifications for using that information. So it could be for use in legal proceedings, particularly if there's criminal allegations being suggested, or it could be if you're using it because there is a substantial public interest for doing so. And if you're using that justification, then you will need to have an internal policy document as to when you are entitled to use that sort of sensitive data, and you'll have to refer to that policy document as your justification for using that sensitive data. So it is very tightly controlled. Consent forms, Not a big fan of them for insolvency work, mainly because consent can be withdrawn at any time. I won't say any more about that. Privacy notices are an important part of GDPR. The general rule is that you should issue a privacy notice to absolutely everybody about whom you are collecting information on your file. And the privacy notice has to follow a statutory checklist in terms of what information you give to the people that you send it to. And there are, broadly speaking, two checklists, depending upon whether you are collecting information directly from the person that you're interested in, or whether you're getting information about them from third-party sources, which again is perhaps more likely to be the case. And the rule is that you really should issue that notice at the earliest possible opportunity, probably at the start of the case. And these are the people that you might be under a duty to issue privacy notices to. Probably the debtor, probably the directors in all corporate procedures, very often the associates of the debtor or the directors, and in corporate appointments, the shareholders as well in many cases. There are exemptions in the legislation that can be useful for you. And looking at those exemptions, they are unclear as to how far they do extend, and it may be better as a matter of routine practice to issue privacy notices rather than to rely on the exemptions, with it being the, if you like, only in unusual circumstances where you decide not to issue a privacy notice. And the exemptions, cases where you may not need to issue privacy notices, but as I've said, this is not really terribly clear, is on your file where you're investigating the bankrupt's conduct or the director's conduct for CDDA, or if there's a file with privileged information on it, or where there's a file that contains information that you need to keep confidential for the purposes of commercial negotiations. And of course, each of the people that you are keeping information about, they have their own individual legal enforceable rights under GDPR, the right to insist that you are keeping about them only the information that you need, their right to receive a privacy notice that sets out what information you are keeping and what you are using it for. And it may be good practice actually to keep investigations as self-contained sub-files within the main case file, particularly if you're collecting sensitive data, so that you can then keep that only on the investigation file rather than the general file. You should think about whether you should be issuing privacy notices on the investigations files, and thinking about whether you might prefer to rely on the exemptions instead. And the reason for suggesting you keep it as a self-contained file is it might be easier for you to manage if you receive a subject access request. And I will say a bit about subject access requests right now. Subject access requests are the right that people have got to know whether you've got any information about them on file, why you've got it, what sort of information it is, who you are sharing it with, how long you're going to keep it for, and other information. And they've also got a right to receive a copy of everything that you've got about them on the file. If they make that request, you can't charge them for providing that information, and you have to comply with it within 1 month. So it's a useful tool for somebody who wants to be difficult, is to make a subject access request, particularly if your file is not well organized to deal with it. Other rights they've got are the right to put right mistakes that you've got about them, a right to have their data deleted, and a right in some circumstances to insist that you stop using the information that you've got on file about them. There are circumstances in which you can deny somebody access to your file. So it's likely that you will be able to do so if it's information that you're using to investigate the bankrupt or the directors for CGDA purposes, or if it's protected by legal professional privilege, or indeed if releasing it might damage negotiations with the person who has asked you to release it to them. And again, it may be helpful in some cases to keep a privileged file of everything that passes between you and your solicitor, for example, which would help you then to identify documents over which you may be able to claim privilege. So that was, as I say, one of the occasional issues rather than one of the regular issues in dealing with GDPR. Another occasional issue is error reporting. And again, this should be part of the training. This is something that people need to be aware of. It is an error if you lose any data, if it passes into the wrong hands, which includes if you receive any data that you really shouldn't have, no matter how useful it might be for you to have it, or if you keep any data that you don't need or should not have. And there are some examples on that slide as to what that might be. And you need to make sure that people are trained on errors. Again, I'll skip over that slide. And there is a legal duty on you as a data controller, and that might be either the professional firm or it might be you individually as an insolvency practitioner, depending upon the circumstances. Legal duty that you have to react quickly when there is an error, to assess how serious it is, and in some circumstances you may have to report it very, very quickly to the Information Commissioner's Office, and in some cases you may have to tell the people whose information has been compromised about the error as well, to give them a chance to mitigate the damage as well as whatever you're doing to mitigate it. I'm now going to move on to the second and third of the, if you like, the management issues. And my apologies because I am running slightly late for this, so I will whisk through them as quickly as I can. And they are the policies that you should have as a firm and an insolvency practitioner, and the issues that your compliance partner should be thinking about. So I will just whisk through the policies very quickly. You need policies on training, on physical data security, making sure that paper records are safe, on digital data security, on file management to make sure that people are using sensible working practices to keep information safe. You will need legal stuff. You'll need to make sure that you're recording the right basis for using data, and you'll be sending out privacy notices. You'll need consent forms for those cases where you may be relying on consent. Much more important in your professional firm than it is for you as an insolvency practitioner to be using consent forms. Privacy notices need to be part of the policies, and you need to have policies on error reporting. So when things do go wrong, it's easy to find out what you should be doing. Similarly, when subject access requests come in, you will need to ensure that you know what you should be doing to deal with them. Sensible to have policies for corporate appointments, particularly administrations, for pre-appointment and immediate day one security reviews, for security reviews on trading, asset realizations, and dealing with HR records. And you may have other sensitive records as well. If you're dealing with something like a care home or a school, you may have quite a lot of sensitive records that you need to deal with some way or another. So those are the policies, and a couple of points for your compliance partner or compliance director, as the case may be. First one is you do not need a statutory data protection officer as a firm of insolvency practitioners. Second one is the compliance role generally. Your compliance director, compliance partner, they've got a general duty to make sure that the firm's compliance matches the law, and that will include GDPR as well as everything else. So we'll need familiarity with the legislation, And there is also guidance available from the ICO, from R3, from your regulator, whether that's ICAEW or IPA, and from myself and other solicitors, of course. Just be a little bit wary about the generic advice that you get, which is probably going to be very helpful, very useful for compliance within the professional firm, but which may be really quite unhelpful in terms of compliance with the specific issues that will affect appointment-taking office holders in insolvency practice. And so, yes, the other part as well, I suppose, is to make sure that you are registered and the registration fee is paid annually. And again, as insolvency practitioners, you'll need to be registered twice. Your firm will need to be registered for the records that it keeps, and you as an appointment-taking office holder will also need to be registered. I understand that the ICO will accept a block registration of all insolvency practitioners in one firm collectively, rather than insisting that each one has to be separately registered. But there are distinct roles where you will be data controller, both as the firm and also as an individual appointment taker, and you'll need to be registered for both of those. And that's just a list of what the compliance officer is likely to have to think about. So with that, and I do apologize for going somewhat over, that brings me to the point where I can now ask if there are any questions. I haven't received any yet, so if anybody would like to ask any questions, then please, this is your opportunity to do so. Otherwise, I will say thank you all very much indeed for joining me on this. I really thought this would be a very niche topic, and I was expecting maybe half a dozen or so people to turn up to it. So I was delighted to see that the registrations for it were well into 3 figures. So thank you very much for your support for this. And I will, I hope, be speaking to you again on the 3rd of October, when we will be talking about administration bear traps. So thank you all very much and enjoy the rest of your day. Goodbye.